Afternoon. You're very, very welcome to this second webinar in a joint series that we here in the OUTLaw Network are running in conjunction with our friends, the Equality for Children campaign, dealing with various aspects of the Child and Family Relationship Act 2015. We're joined today by two absolutely excellent speakers, Nuala Jackson, Senior Counsel, who is going to speak to the various legal aspects of the legislation, and by Mary O'Dwyer, Barrister at Law, who is wearing two hats today and will be speaking both to her personal experiences and perhaps the legal aspects of the Act as well. For those of you who don't know me, my name is Gerard James. I am a Senior Associate in William Fry, working on the commercial litigation team. I might just add on a housekeeping note here, which I probably should have done at the outset. If everybody could ensure that their mics are muted and their cameras off, we will be recording this program and making it available hopefully later today or tomorrow on the OUTLaw Network website. So if you miss anything, feel free to log back in. The recording from last week is hopefully going to go up on our website later on today. So the idea will be that at the end of the series, all 4 webinars and lectures will be available online. Just to go back to touch upon OUTLaw, OUTLaw was set up in 2019 with the express intention to promote and drive diversity and inclusion within the legal community. We are open to members and attendees across the legal community, be you a trainee, a sole practitioner, working in a firm or a wider organization, LGBT plus or an ally, all are welcome. Our focus has to date been on running events dealing with issues of concern to the LGBT community through the lens of the law. And hopefully once we get through this present COVID period, we'll be back to running our in-person events. So on that, I'm going to hand over to my co-presenter and moderator today, Ranae von Meding of the Equality for Children's campaign.
Thank you so much, and thank you everyone for joining us again today. I'll just do a very quick introduction because I did a more in-depth introduction last week, but I would think that many of you here today were also there last week. So my name is Ranae and I am a same-sex parent with my wife Audrey. We have 2 daughters, Ava and Aria, who are 4 and 2. And I also am the CEO of Equality for Children. So Equality for Children is a not-for-profit organization that was founded in 2019 with the sole purpose of fighting for equality for all children of LGBTQ plus parents in Ireland. We work in a couple of key areas, and one of those is raising awareness and providing support for LGBTQ plus parents and prospective parents. We are delighted to be partnering with the OUTLaw Network to provide this series of free events, which I think are so necessary for our community. As you know, personally, I have found in my own parenting journey it difficult to access information. So I think it's very important that these events exist. So thank you so much to Nuala and Mary for joining us today to provide us with your expertise and your insight. And I know what we talk about will be very beneficial to everybody watching. So thank you very much.
Well, thanks, Ranae. And on that note, I'm going to introduce our first speaker, Nuala Jackson, Senior Counsel. Nuala is a Senior Counsel specialising in family law and child law. She is currently the chairperson of the Family Lawyers Association of Ireland. It's a particular interest in legal issues relating to family formation. Nuala, I'm going to hand over to you.
Hi, good afternoon, everybody. I'm going to share a screen with you at this point, just to bring up a PowerPoint. Now, and hopefully this works. Never work with PowerPoint children or animals. One of the things, and I suppose I'm practicing family law, child law for a very long time, and one of the things that always strikes me about Ireland is that everybody goes very mushy about children, but part of the issue in Irish society has always been that while we're gush about children, we're very dictatorial about how you get them. So that the reality is that a lot of the issues that are being addressed by this group are issues that have been faced by others in the past in a very, very, in many ways, cruel scenario. So we have a situation, and historically, and I know I haven't a very long time to speak, and I'll run through the actual law, which is massively tedious, but it always strikes me that, you know, you have a situation whereby children are born within marriage. As soon as people are married, and I'm talking about heterosexual marriage, people are instantly wanting to know when people are going to be grandparents and when you're going to have a child and da da da. And all of this is all kind of very much part and parcel of our society. But if you have a situation whereby for any reason, and of course I do work a lot with same-sex couples who are trying to start families, but of course in addition to the very, I suppose the biological challenges that are faced by same-sex couples in that context, of course you have this enormous group of people where these difficulties derive from tragedy, personal tragedy, illness, from circumstances beyond their control. And you do find that when you get into that area in Ireland, there is opposition, and there is it remains difficult, and you see this particularly one of perhaps the most one of the most common journeys now, both for same-sex couples or indeed for other people with conception difficulties, is the surrogacy route. And we have a situation in Ireland whereby surrogacy is really, it's kind of like putting a square peg in a round hole. You really have a situation whereby we don't really have any law. We kind of skirt around it. We try and make the pieces that are there fit to give a very unsatisfactory solution at the end, or perhaps not so much unsatisfactory, it is unsatisfactory, but it's definitely incomplete solution to the problem at the end of the day. So what I want to do today is to just take a very broad brushstroke approach in relation to family formation in Ireland. And as I say, hopefully this, as I say, very quickly. Who are parents under Irish law, and does it matter, I suppose, is the first thing. The word parents, and indeed any of these words, are difficult in the context because they, they change depending on different legal contexts. But in addition to that, you have a situation whereby the normal colloquial understanding of various terminology doesn't fit in with the law. And I suppose if you talk about a child and you talk about their parents, you're traditionally you're talking about father, mother, or indeed whether you have two fathers or two mothers or whatever, doesn't make any difference. The legal definition of father and mother has been pretty well established in Ireland. The definition of a father under Irish law is the genetic male parent of that child. And mother, since the O'Oran and Thord Cláraitheoir, which was the surrogacy case that went all the way to the Supreme Court, the mother is the person who gives birth to a child. Now, what has happened in relation to these concepts is that, in fact, in the context of same-sex couples, in fact, in some instances, male couples are slightly in a better position, and in some instances, female couples are in a somewhat better position. And the reason I say that is that in the context of surrogacy, if you are resorting to surrogacy, you can never be the mother of that child. So therefore, if you're talking about a female couple, surrogacy cannot be the route forward for you, because if you're going to use a surrogate, the surrogate is by law the mother of the child. So that is a limitation, whereas surrogacy is a very common and relatively and a well-used route in the context of male couples who obviously the father of the child is the genetic male parent. So that is a route. Whereas then we come along, for example, when we come to the changes that have come about in relation to registration of births, which we'll look at very briefly later on, they have favoured females rather than males. So again, the law really does need a great big overview. And part of the problem is that the changes that have been introduced have been very piecemeal. Okay, so what is the legal significance of being a parent? I suppose in essence, it is, there is, I suppose per se, save and except with the exception of the mother of a child who has constitutional rights, married parents who have constitutional rights. The significance of being a parent is probably not enormously what the law looks at, because what the law breaks down into in terms of parental rights is really the trio of guardianship, custody and access rights. Now, of course, guardianship, custody and access rights really only apply in the context of exercising some sort of parental responsibility vis-a-vis a minor child. Part of the difficulty, if you go down the route, and this is something that for example, people find in the context of surrogacy, in the context of the guardianship, expansion of guardianship rights of cohabitants, civil partners, etc. One of the difficulties is that if you want to get into kind of deeper stuff like taxation, things like immigration, things like citizenship, etc., then guardianship, custody and access aren't what you're looking for. In those circumstances, you really do have to look at establishing a legal a parent-child, a father-mother-child relationship in order to get the benefit, with a few exceptions in terms of various revenue allowances. The one thing you can rest assured in Ireland is that you can never state anything definitively. But in the context, and as I say, part of the difficulty is that when you're working out these problems, guardianship, custody and access may be the ones you want to focus on when a child is very little, but you do have to project forward and say, well, what's going to happen later on? What's the revenue position here? What's the immigration position here? What's the citizenship position here? And you do find, and again, this isn't anything particular to those with an interest in this group, but you do find, for example, people who have adopted children abroad where the adoptions aren't recognised in Ireland, and they suddenly, and indeed very often these problems don't actually come to light until very, very, very much further on. And you end up in a situation whereby you're not actually looking at the problems that may arise during a child's minority, but you're actually trying to sort out a legal status issue, a legal relationship issue for the purposes of those other much more lifelong situations that arise. Custody and access are as broad as they're long. In effect, there are now, under the 2015 Act, there are vast tracts of people who can apply. I call the 2015 Act the Act that filleted children, because everybody bar God, and probably God as well, are entitled to apply to have access or custody or some breed of visitation. And I sometimes wonder when children actually get to be themselves and to not have calls upon their time going hither and thither and yon, because at the end of the day, I don't know about everybody else, but if I'd spent my childhood having to do access visits with grannies and granddads and parents and whatever, I think I would have found it all massively restrictive. So I think there is a huge sense when we're dealing with child law that we focus on what adults might want, and we perhaps don't quite so much focus on what children might want. And I'm not talking about the voice of the child as such, which is a big issue, but looking at things on the basis of the very practical day-to-day impact that these things have on a child's life and a child's lifestyle. Because I think I used to have a rule of thumb, which was that I really didn't expect a child to engage in any custody access arrangement that I wouldn't do myself. I gave up on it because, in fact, the reality is that most custody and access arrangements for children that I come across nowadays involve so much chopping and changing that I couldn't be having it, lads. I'd be off I just couldn't do the amount of upping and downing and going from this house to that house and whatever and whatever. So I'm afraid I had to my rule of thumb that if I wouldn't do it myself, I wouldn't expect a child to do it, I'm afraid is one that's had to go by the wayside. But guardianship is an interesting topic, and I know, as I say, I'm probably over time already. Guardianship is, of course, the bundle of rights in relation to decision making concerning a minor child. Guardianship, traditionally, the cases said that there was physical, psychological, social, religious, and financial concerns that arose, educational, arose in the context of guardianship. It's essentially who makes the decisions for a child, and those decisions are made by a guardian. And if there's more than one guardian, by agreement between them, or alternatively, if they disagree, by a court. So, in essence, guardianship is the big ticket item as far as minor children are concerned. And there is no doubt that there has been a vast array of improvement there in circumstances where a number of people, I think probably it's fair to say that Section 6C is the one that will have most application here. It's the application for guardianship by partners, civil married partners, civil partnership, or 3-year cohabitants, having shared day-to-day control, day-to-day care of the child for more than 2 years, 12 months if there's no other functioning guardian. So essentially, it allows for marital partners, civil partners, or indeed cohabitants to seek guardianship in relation to a child that they are bringing up with the parent, mother, father of that child. So I suppose that's, but a whole new array. Essentially, we had just the original Section 6. There was provision for the 6A that normally that's relating to an unmarried father, where a parent of a child who is not a guardian, but the others were all new, brought in by the 2015 Act. Moving on then to surrogacy, as I say, what happens in surrogacy is essentially, in most instances, in order to have a successful surrogacy arrangement in Ireland, in terms of Irish law, you have a situation whereby the genetic material for the child is the male. It comes from the male of one of the partners, and essentially the child gets Irish citizenship, gets a link to that partner, that parent, through a declaration of parentage and an appointment of that person as being the guardian. In those instances, the other partner usually has to wait until they can apply under the Section 6C. The Section 6C rules to get guardianship 2 years later. The difficulty being for the surrogacy to arise, there must be that genetic link in order that you are, under Irish law, recognised as either being the legal father or the legal mother. And in fact, one of the things that does arise frequently here is that the genetic material of the female has been used. It's not a donor egg, but an egg of one of the parties. And in that instance, it isn't sufficient to give the link for surrogacy by virtue of the fact that the mother of a child under Irish law is the person who gives birth to it. So surrogacy, as I say, at the moment, we're really just using the declaration of parentage together with guardianship and custody rights an application under the Passport Act to dispense with consent of the mother. So it's kind of bringing a load of things together to address various different parts of the problem, but there isn't an overarching scenario that arises. I've then just set out there for you the civil registration situation. This, of course, has been in the situation of where there is donor-assisted human reproduction, where you have a situation whereby the partner gets rights and there is a potential for registration of that partner in the context of being the parent of the child. And obviously this is the provision that came into force relatively recently. It was on the books for a long period of time before it was commenced, essentially where you have a situation whereby technically the partner of a person, where in most instances where the genetic material was not that of the father of a child, you then have a situation whereby this provision vests parentage in the party who was essentially the de facto parent in that arrangement, and then the amendments to the Civil Registration Act to look after that as well. The last one that I have looked at is the question of adoption. And the reason that I have put up this photograph is kind of a be careful what you wish for, because I'm in the fortunate position that where some people own the leg of a horse, I own the leg of a child, because I happen to share accommodation with my sister, who adopted this Draculan-looking creature from Vietnam a number of years ago. I as I say, adoption, they do grow up. She's now almost 20. But as I say, you too can have a Dracula in your house with oozing blood. So this is where I'm just very briefly to look at adoption. And of course, in the context of eligibility to adopt, there were significant changes made in the Adoption Amendment Act of 2017. Traditionally, adoption in Ireland was limited to married couples, and I suppose in that context, married couples involved married heterosexual couples. And then there was this kind of broad, vague category of single people where adoption was appropriate and in the best interest of the child. And they were the only two grounds, originally just part A on the PowerPoint. Moving on, it moved in then to number B. However, the difficulty was that there wasn't a facility in Ireland for couples adoption, and the 2017 Act deals with that. So we now have 4 categories. Obviously, category A of married couples has now extended as the definition of marriage, or the eligibility for marriage has extended. So has the definition for adoption by married couples. The single person still arises, and then we have eligibility for adoption of civil partners and cohabiting couples where there has been no less than 3 years cohabitation. So that's my whistle-stop tour of alternative family formation in Ireland, and it is really just a small bite, and I know I've gone probably way over time. Thank you all.
Nuala, thank you for that. That was an absolutely fascinating overview. I think if you'd lectured me in college, I may be a family law or a family law solicitor at this stage. And I'm certainly going to borrow that quote around the Act, in terms of being the Act that fillets children. So thank you very much for that.
There you go. How fortunate you could have ended up being a family lawyer.
With that fresh in our minds, I'm going to pass over to Ranae, who is going to speak with Mary around her personal experiences under the Act.
Thank you so much, and thank you, Nuala. That was amazing, and yeah, I could listen to you talk about this all day. I am going to speak to Mary O'Dwyer, who is a same-sex parent, also works in the legal field, so is wearing 2 hats today, as you said, and also is a member of Equality for Children, and we work together on that campaign. So I'm delighted to have you here today. Thank you so much. I'm actually going to put up some pictures that you shared with us. while you kind of tell us a little bit about your family, if that's okay.
Yeah, no problem. Hi to everybody, and Nuala, thanks very much for that. I'm absolutely, definitely not an expert, and I'll qualify my appearance today with that. And so it is very fascinating to listen to somebody with your level of experience in the field. Yeah, this is my family. That's Paula, my partner, and that's our little son, Freddie. He's going to be 2 at the end of July. And that's us just after his naming ceremony that we had last year around his birthday. So Paula and I, we met, oh, there he is today. This is the new thing, is to carry the bucket and collect stones to throw them in a fountain in the local park. So basically, Paula and I met about 8 years ago now. She was here to learn some English. She's Brazilian, and she had plans to go further afield to Australia, but she met me, and that put paid to all her fun. But we very early in our relationship, I think we, you know, spoke about the idea of our hopes for the future, to become parents. We were both thankfully on the same page in that regard. And yeah, we just, when the time was right, we decided that, you know, we'd look into the process and we'd see what our options were in terms of, you know, trying to create a family. And I suppose the benefit that I had was that I had a kind of a broad understanding that there was legislation there that effectively, I suppose, provided for a situation where I could achieve a pathway to parenthood in terms of a child that would be born to Paula, and vice versa if I were to carry the child and give birth. In that regard, I suppose, to a degree, it was kind of limiting, because I knew that there was certain criteria that we had to meet in order for me, at some stage in the future, if Paula was to successfully carry a child and give birth, that there was a pathway open to me to be recognized as a parent, given the current legislative framework that was in place, and that was the Child and Family Relationships Act. Now, I knew that the particular provision that would ultimately achieve the recognition of my parentage hadn't come into effect as of yet. So at the time we went through the process, we were very much, in terms of the clinic and going through all of that, it was very much acknowledged that I was the intending parent at the time, and we knew that at some stage in the future I would be able to apply to court for a declaration of parentage, but it wasn't a reality at that particular point. So that was naturally, I suppose, a bummer. You know, it was something to kind of say it's a bummer, but what it also did was, I think it limited us, and certainly the way we thought about how we would go about actually creating our family. I felt that we needed to tick these boxes because I was sure I'd be able to then become a parent to my child. And it ruled out other options like...
Yeah, so I was going to ask, you know, so obviously a lot of people maybe went into this process not, you know, having the benefit of all that knowledge that you had. But if those constraints hadn't have been there, do you think you might have gone down a bit different path in order to conceive a child? Or
yeah, I definitely think we would have explored all of the options available to me. I felt that we had a certain very rigid kind of process that we could engage in to achieve what we wanted to. So it meant it ruled out things like using a donor we knew, like or a family member, as many people do. They, you know, they might use a donor who'd be a sibling of one of the parties, or, you know, the home insemination process, or to travel abroad and look for treatment abroad, because the reality of it is that sometimes that can be a more affordable option. You know, even all of I've mentioned maybe more affordable options for couples. But, you know, I felt, look, there's one certain way that I could achieve a recognition of my parentage of my child, and that was to go through the criteria set out by the CFRA, the Child and Family Relationship.
And so when you first had your son, you were not recognized.
No, I wasn't.
And what was that like? What, you know, I obviously, from my personal experience, you know, our family is in that situation also. But, you know, what was that like to, you know, become a parent for the first time and to know that your family was not recognized under the law?
Yeah, I suppose it was, so it's when your child is born, you know, there's a mixture of emotions as it is, and you're just absolutely, I mean, you're just so thrilled with this little bundle that's in your arms. And then all of a sudden the thoughts start to invade your mind, you know, that, God, I have no legal relationship to this child, despite the fact that we went through the process of getting pregnant together. I was there for every minute of the pregnancy, and, you know, I was there for every minute after. So I guess, you know, it was a really, I suppose it was a bittersweet time. We had this beautiful boy, but yet I had no legal connection to him in any way, shape or form. And I think that that lends itself to a feeling of an incompleteness around your family, and also just, you know, the moments of panic. You wake at 3 o'clock in the morning if you're not having to give them a bottle or resettle them or whatever. You wake at other times with this kind of panic. Well, I felt that's what used to happen to me, and the what if, you know, what if something happened to him? What if something happened to my partner? I had no legal rights. I had no entitlement to make a decision around that child, anything that happened with that child, their future, you know. And it was, yeah, as I say, it was bittersweet. It's so beautiful to have a child and, you know, to have that experience. But then, you know, the flip of that is, I didn't have a legal connection, and I found that tough at times. I really did. I found it tough. I think most people do when you speak to them about it.
Yeah, it is. It's really hard because, you know, some people say, well, it's just a piece of paper, but that piece of paper, as we heard from Nuala, allows you as a parent to provide your child with so many securities and privileges that a parent can, you know, pass on to their child. So how old was he when you did get a declaration of parentage?
So it was about 2 weeks before his first birthday. That's when we managed to get our application through, because he was born in July 19, and then in May the following year the legislation came into effect. And so naturally we went about the process of putting in an application as soon as we possibly could, and trying to get that through in the district court. We were actually very fortunate because obviously I knew my way around the paperwork and the various affidavits that needed to be filed and all of that kind of stuff. So we were able to do it ourselves, and we were very fortunate in that the application was in Dublin before the president of the district court, who was very much welcoming the applications and prepared to make them, you know, if there was nothing arising that raised an issue, he was very happy to grant it. And it was a beautiful day, I have to say. I didn't expect the emotions to be as significant as they were. I think that in terms of the application, it was very sweet. It was very lovely. The judge was just so nice, and we did it over a call like this because of COVID. And he welcomed the child coming onto the call and all of the rest, you know, so that was beautiful. And I think once we had switched off the call, I just remember this overwhelming sense of relief. And I cried, and I didn't think I would, and I cried, and we have a picture, and I look quite interesting in it. I was just so emotional. And I have to say, you know, you then kick into, okay, now we can apply to re-register in terms of his birth and registering me as a parent. And I have to say, when we got the birth certificate in the post, I opened it, it was like a million Christmases at once. I felt like I was 2 foot taller. I was so excited, rang all the family, and yeah, it was a beautiful time, beautiful day.
So I suppose, what does that mean to you now, to just be treated equally? And do you have any feelings around the fact that you didn't have it right from the start when you should have? You know?
I suppose in the world we live in today, and especially after the marriage referendum and all of that, I suppose I'm a little resentful that it was something we had to go through. On the other hand, I know what law is like. I know what the legal system is like. I know how difficult it can be to get legislation, you know, across the line. I know how difficult it can be and how long it takes to achieve change. So I suppose I weigh it up, you know, with that, but I have the benefit of being a lawyer in that respect, so not everyone would have that perspective on it. But it feels amazing. One of the things we did when Freddie was born, we gave him the double-barreled name, you know, and a lot of people say, oh, Jesus, you know, it's bad enough that they've got two moms, now they've got a double-barreled name, that kind of thing. But to be honest with you, that was my way of protecting us in a situation. I really feel it was like trying to protect our family in a situation where, let's say, for instance, I needed to travel alone with our son, or he needed urgent medical treatment, that my parentage wouldn't be questioned because he has my surname. And, you know, it was kind of, you know, they'll probably think that the other name is the dad, you know, and at least then there won't be any questions around it and we can just, you know, but I felt that that was something that was me jumping into protective mode at that point. But now it's, you know, doesn't matter what his surname is. The fact of the matter is I'm a parent as much as Paula is. So, I mean, I can't describe the feeling, the sense of completeness, the sense of just belonging to each other, I guess.
Yeah. Thank you so much for sharing all that with us. I'm just going to ask you one last question, and that is, what is your favorite thing about being a parent?
Oh, the sleepless nights. I mean, 21 months of that, fantastic. No, it's not that. I guess it's just the love you feel for another person, like a little person I guess a lot of parents say, like, you can't really describe the feeling. It's when he wakes up in the morning and he sees your face and there's the smile. You know, I mean, it's a form of drug you could never replace. I can't explain it. It's everything I thought it would be and a million times more. So it's great.
Thank you so much. I am now going to open up the floor to anyone who might have a question, either for either of our guests or for the hosts. You can just unmute yourself, maybe introduce yourself, and then ask your question. So we have about 15 minutes for questions. So go for it.
I actually might jump in on a quick question just to get the ball rolling. And this is a question actually, Mary, for you. In terms of the actual process, so I'm asking you wearing your legal hat here. How long did the actual process take before the district court, from the issue of the application to the hearing? And I suppose how much work was actually involved in that process? And is it something that you think parents from a non-legal background would be able to run themselves, or is that something that you would advise that legal advice be taken?
Yeah, and for us, it was, you know, once the legislation came into effect, we acted, you know, relatively quickly. But it became very apparent that I don't think that word had filtered through to the judges that this legislation had come in. I'm not sure that they were all very prepared for it. So I think there was a certain apprehension around the applications and just becoming au fait with the legislation. So initially there was a delay because the rules of court hadn't been signed off on, and that ultimately delayed it for I think a number of weeks. How long that was, I can't remember, but I think we put in our application in June, towards the end of June, and we were given a date in kind of mid-July to have our matter dealt with. I have to say we were very fortunate because in Dublin, the registrar we were dealing with was incredibly helpful, and it was as though they had kind of set up a team that were going to deal with these applications, you know, to kind of get the paperwork in order and set dates for when the applications could be made. So from our perspective, it was relatively quick, albeit that there were certain delays that couldn't be helped on anyone's side, and the district court rules had to be effectively signed off on in order for the applications to be formally brought before the court. But, you know, it was relatively quick from our perspective, I think.
Okay, yeah, no, by the court standards, that sounds very, 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 very quick.
Yeah, and I think it's because there was kind of this, I'd say it was a bit of a deluge. People were contacting the district court offices, you know, going, when can we bring these applications? Because people were just, you know, as I say, I was in a situation where I had no legal connection. It was going to be another year before I could even consider guardianship, and guardianship gets me to the age of 18. That's it, with, you know, in terms of your rights with your child. So yeah, it was kind of, I think it was just a case of they found that they had gotten a serious amount of applications or queries, and they said, right, we have to organize ourselves. And they did. I have to say it was quite efficient from my perspective. Now, I do know, and I've heard anecdotally, that there have been some applicants who have experienced a very different process. It's been more difficult, and that there's a combination of factors, it appears, for that, none of which I'll comment on. But, you know, we were fortunate, but not everyone is going to be as fortunate as that, I think. And there probably are certain delays now because of.
I think it is fair to say that the legislation, the legislation was commenced, and pretty shortly afterwards we got into a COVID situation.
Yeah.
The district court really hasn't been operating at full kilter for anything. It has managed to keep going with an inordinate degree of success, and it's fair to say that, and full credit to district judges who have continued to operate a system pretty impressively over the course of lockdown. But I do think that it is highly unlikely. You will get disparities across the country, you always will, where you've got different courts, but these are they're not contested applications. And I think as Mary said, there may have been, and again, remember, it came into the system at a time when the system was extraordinarily challenged. I think the position now is that there is very, very keen awareness by district court judges about this jurisdiction. It's not a contested jurisdiction, so it's not like you're going to have something that's contested and you're adjourned from list to list to list. I suppose you may get some courts that are more pedantic about these things than others, and they may put you back on the basis of proofs not being in order, but it really is an uncontested application once you have your proofs. So, I mean, I wouldn't envisage that they would be it's an application that would take very long. Again, district court lists vary. You probably will find in time to come that Mary's experience in Dublin may well not be what continues, because Dublin's district court is such a challenged district court. You may well find that when you issue your summons that you won't get a return date for 3-4 months. Whereas in other district court areas, it would be routine that you would get into the next session of the court, and the court might sit, some of them weekly, some of them monthly, whatever, so that you would get into that. But as I say, that won't be any different to what's experienced by any other litigant, and they should be much less contentious applications.
Yeah, I think you're definitely right on that. I mean, I'd have to commend the district courts, the judges and the staff, that, you know, the amount of work that they've gotten through, and in particular in relation to these applications and other work. I mean, they've been operating more or less at full kilter, and the other courts not so much, for various reasons, but they've done exceptional work. And I think in respect of these particular applications, there's no doubt about it, they've managed to process and get these applications done and dusted very quickly, given what have been the very obvious constraints that they've been operating under with COVID, you know.
Okay,
Hi, Mary.
Go ahead.
Just on that point there, and my name is Jenny. Myself and my wife have a little boy, and we're in Wicklow. And on a point that somebody made earlier on, we had kind of waited, I think, for a few months to put our application in, to give the court some time, so we had no knockbacks. And we got our declarations, our affidavits signed by a peace commissioner last week, sent them by registered post to the court on Friday, and today, Wednesday, we have a date already for July. Well, it was for July. I actually thought it might be a bit sooner, but we're completely happy. But I suppose, kind of on a bit of a funny anecdote, we got the court order request back with the posted with the date, So, you know, they're just processing them through. So for anybody that's kind of maybe in a, not that Bray in Wicklow is rural, but that's outside Dublin is worried, they processed ours pretty quickly. And I believe in Bray, my area, there's been a couple of cases put through similar to yourself, Mary, with no issues. So, you know, I think the smaller district courts are definitely getting there and processing them really, really quickly.
Yeah, I think it is really important in this area to say that it really is, you know, I know that it was Mary, you were saying about, you know, what's the best thing about being a parent and whatever, and not wanting to rain on everybody's parade, but unfortunately that's the end of this that I come from. It is really important that de facto families take the initiative to get their situation regularized, because I know that I have over the last, in fact, it happened when divorce came in Ireland, that, you know, you had people who married immediately afterwards, and the marriages lasted a very short period of time because they were relationships that had almost exhausted, and they got married in circumstances where it was, they had just waited so long for this. To some extent, not the same extent, there has been a little bit the same in relation to same-sex marriage. People who have been in relationships for so long where there may be enormous relationship challenge, but because they'd waited so long, they went ahead and got married. So I have at this point, and I know my colleagues who operate, I would primarily operate in the High Court, but my colleagues in the District Court and Circuit Court have regular applications in relation to the breakdown of relationships. And let me tell you, I have been in circumstances where people are part of a cohort who have fought very hard for their rights. It never ceases to cause me enormous concern, the way in which the non-legal parent, if they haven't regularized their position, is treated in the breakdown in the context of same-sex relationships. I have come across, and again, I don't want to rain on people's parades, and I hope everybody's relationship is happy forever, but I have come across cases of people who have brought up a child together for a number of years, and the relationship breaks down, and literally they say, this isn't your child, go away, and they seek to bring the shutters down completely on that relationship. It is, I mean, it's always tragic, and it's an awful thing if somebody has been part of a child's life, that somebody thinks they should exclude that person from the child's life. I always, and I have to say, I'm not trying to not trying to put a higher onus on people whose relationships are people engaged in this group, but in circumstances where you're part of a group who have fought so hard to get where you are, to then see someone turn around and say, well, no, you may have been around for the last 5 years, but go away, you've no legal rights. And that is happening. So therefore, and again, it is really important that people like Mary go and get that application made. Because at the end of the day, you then come in on an equal playing pitch. I'm not saying there's an awful lot of sympathy, but there may be a lot, to some degree, a court can be curtailed as to what they can do to help in these situations. But at least you come in, the child can then, arrangements can be made without filleting them, appropriate arrangements can be made. But I'm just putting up the red flag. It's not just something that's there, it's something you need to implement, because otherwise, when things go wrong, the level of acrimony is no different than has been challenging family lawyers forever.
Thank you so much, Nuala. That is a really important point to make. And yeah, I would really urge and encourage anyone who is able to make an application under the CFRA to do so kind of with urgency. I know at least in Dublin, I think they have a date coming up soon. I'm going to try and get through some of the questions in the chat. And just to mention, if we don't get to your question, or if you have a specific question that you would like us to try to answer, you can contact either the OUTLaw Network, or you can contact us at EFC, either through our websites or through the social channels. But we will try and get through these questions if we can. So the first one was from Louise, who I think also has her hand up. I'll just read it out, Louise, and then maybe if you want to unmute yourself. So Louise is asking, is there any situation whereby couples conceiving with home insemination can apply for recognition of parentage? Or do you just need to go through the adoption process? Nuala or Mary, do you want to answer that, or I can answer that?
Oh, I think you're on mute, Nuala.
Well, no is, I suppose, the short answer to the first one. And in relation to adoption, no-ish, maybe yes-ish. Let's be more positive.
Yeah, so there is no legislation to do with home insemination, or otherwise known as intracervical insemination at present. So yeah, the answer is no. The CFRA only governs procedures that take place in an Irish fertility clinic, and retrospectively, foreign clinics are included for prospective recognition. But going forwards, if you're planning to conceive and want to be covered under the CFRA, you would have to go through an Irish fertility clinic.
And there will be significant adoption problems. The adoption board is raising a number of issues that are some of it, again, it's a very complex, but on the grounds of public policy as to whether if you are in a system, if you adopt a methodology of conception, and I say that in a very broad brushstroke way, whether or not there is a public policy against the allowing you to cure that through adoption. That is going to be the subject of litigation, in fact, very shortly. I think there's a case listed, not on the direct point. So I don't think, when I say adoption, I say yes-ish. It depends what happens. It's not, people should not rely on the adoption process as being something that can rubber stamp on anything that just can't be otherwise regularized. There are very significant issues. The adoption legislation in Ireland is massively restrictive.
Thank you, Nuala. One of the questions here on the chat is to do with surrogacy and same-sex male couples, and Maeve actually just replied to that, saying that we're going to have a specific session on surrogacy in week 4, so maybe we will leave that question to week 4 if that's okay, just so we can get through some more questions. Dorothy is asking a question about whether a guardianship order is required in addition to the declaration of parentage, or once you have the declaration of parentage, is that everything sorted?
Once you have the declaration of parentage, you're a parent. You don't have to concern yourself with the, at that stage, you come into the situation. You don't have to worry about the guardianship as well.
Perfect, thank you. One other question is, what is the process after guardianship? Is it adoption? So Ethna, is that question to do with if you don't qualify for parentage, and if you're going for guardianship as opposed to parentage? Would you be able to unmute yourself?
Yes,
and maybe
she said it is.
Oh, okay.
Yeah, I mean, the long and the short of that is that adoption is not necessarily going to be available or appropriate. It may be as something that arises. It may be that you can apply to adopt under the broader categories set out in the 2017 Act. I suppose to some extent your question is guardianship the sticky plaster and effectively adoption the full cure? And yes, in theory it is, but they are very distinct things. They're very distinct things. My view is that in terms of dealing with a minor child, you must focus on getting your guardianship sorted out if you are not able to go down the situation of getting full parental recognition. I think getting your guardianship sorted out. Remember, of course, you can only adopt in Ireland, you can only adopt minor children. So therefore adoption does, if it's something you have to look at, but they're very different. They're kind of two parallel streams that don't really interlink, but one does give you obviously a much more solid, it gives you a legal status. Guardianship is not a legal status. Guardianship is just a conferring of rights and responsibilities.
Thank you. There is one more question here. I think we'll just do one more question, and then if there's any additional questions, if you really would like them answered, you can feel free to contact us. This is from Irene. My wife is Belgian and had automatic parentage rights to both our children when they were born in Belgium. It would appear that the children only now have one legal parent here, now that we have moved to Ireland. Can my wife apply for a declaration of parentage?
Again, quite complicated, because under the Hague Convention in relation to parental responsibility rights, you will still be entitled to carry over the rights that you had from abroad in a country such as you say. There is also a provision in relation to guardianship in, I think it's section 6D of the 2015 Act. So again, it's one that you would need to specifically look at. I think you probably don't need to, but again, I just would need to know your particular circumstances.
Okay, thank you so much. Maeve has also just popped up the link to next week's event if anyone wants to sign up. I'll hand back over to you, Jared, but thank you so much, Nuala and Mary, for speaking to us today. I would think that everyone has found it incredibly informative and helpful. So thank you so much for giving your time.
Thank you.
Thanks, Ranae. And just to echo your words of thanks to Mary and Nuala, just for me personally, that was hugely informative, hugely interesting, and I would happily listen to you both all afternoon. So thank you again for volunteering or being volunteered to speak to us today. Just on Maeve's email into the chat, we will be returning again next week for the third episode in the series, which actually relates to parents who can't apply or aren't in a position to apply for various protections under the Act. So that is going to be a very interesting and hopefully informative session with some different speakers. But I think to just wrap up, to say thank you all for taking the time out of your busy days to dial into this. In the event that you do have any particular queries, as Ranae said, feel free to contact either ourselves here at the Outlaw Network or Ranae and Equality for Children, I should say, as opposed to Ranae directly. And I think we'll leave it there. So thanks all, and look forward to seeing you again next week. Take care.